Contracting ultimately is a promise of value delivered. And not being able to connect the dot between the promises and the value that's promised inside a contract makes no sense at all.
Today on Law Next, a conversation with Ajay Agrawal. He co-founded the pioneering legal outsourcing company UnitedLex in 2006, sold out his share in 2011, and then went on to found his present company, Syrian Labs, where he is aiming to disrupt the field of contract lifecycle management and possibly save companies as much as $2 to $3 trillion a year. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview. Ajay, welcome to Law Next.
Thank you, Bob. Pleasure to be here, and thank you for having me.
Yeah, it's great. It's great to be able to speak to you. And I know that you're. I think you're still in India, right? As we speak, I know we talked a couple of weeks ago when you were in India, kind of stranded, right?
Indeed, I am. I'm based in New York, Bob, and for the last 5 months, I've been stranded in India, given the current situation. Hope to be back in the U.S. soon.
Yeah, well, I hope you're finding some good use of your time there. I'm sure you are, no doubt. So, Ajay, I want to, of course, talk about what you're doing now, but I'd like, if it's okay with you, to just kind of step back and go back to the beginning and come forward again, and starting with your kind of early days. I mean, you started out as a lawyer. So tell us about that. How did you kind of begin your career?
Yeah, thank you. Thank you for taking me back, although it makes me feel a little bit old talking about those days.
Well, join the club. I'm a lot older than you are, probably.
So Bob, by training, I'm a black letter lawyer. I was trained at Cambridge University at Trinity College in the early 90s, and got a master's at Columbia, and was fortunate enough to practice with two of the leading Wall Street firms throughout the 90s. Starting out at Debevoise and Plimpton in their corporate and specifically their securities practice, where I had a chance to work with some of the smartest minds at the firm. And then the much longer stint was with Simpson Thacher and Bartlett, also in their securities and their private equity practice. And during that period, I was a specialist in the field of asset-backed securitization, which, as you know, grew very, very rapidly right through the 90s and the early part of the last decade, culminating in the events of 2008. For me, sitting as a lawyer in New York, I was always tracking the development of the Asian market. As you remember, the tiger economies in the late 1990s, followed by India's new economic liberalization policy, and the opening up, frankly, of India in the late 90s. It was an event that all of us sitting in New York were watching with great keenness. And I think these events in Asia were exerting a gravitational pull on the major law firms, including the firms that I had worked with, Debevoise and Simpson Thacher, and firms that were very inward looking, very happily ensconced, if you will, in their American and to some extent European avatars, were starting to feel the pressure led by their clients of opening up offices in Asia. And partly as a result of these events, and partly as perhaps a desire to be more homebound, I then took up a position with Jones Day to help set up their securities practice in Asia Pacific at the end of the decade, and moved to India. And for me, this third chapter was arguably the most interesting of the law firm chapter of my life. And largely because Jones Day, being a much larger law firm, had much greater amounts of personnel. And when we got all the way to Asia, what we found is that our clients remained the same, very elite, top-tier investment banks like Rothschild and Goldman Sachs and Morgan Stanley. But the teams that were working on those deals were Asian in origin, had not been exposed to a London or a New York style a deal environment. And the usual style of success, delivering success, high quality in New York or London, was just not applicable in Asia. The New York style is you recruit from very elite law firms and pedigrees. You provide a little bit of training at the beginning, but by and large, it's sink or swim. And that accounts for the pyramidal structure of talent in New York. But in Asia, that level of talent at the outset was not available and simply not possible at the Asian rates. So I think in the case of Jones Day, we had to adapt and develop technologies and techniques really for documenting our best practices, our knowledge, and using that as a substitute for getting the best talent at the outset. And that
so
really,
you kind of had to write the manual, is what you're saying.
We had to write the manual. We had to write the manual, Bob, and we had to use that manual or the Bible to deliver the quality that our clients were expecting or be ready to lose them.
Yeah. And so who was doing that work?
That work was done by the senior lawyers at Jones Day, including me. And frankly, that is what gave us the edge in the early part of the last decade in building that practice. And for me, it was an instructive moment because it showed me that there is no just one path to success. It's great that sitting in New York, we had access to lawyers from Yale, from Harvard, but there is another path to get there. And that path is being very systematic and documenting all our best practices in a way that lawyers from maybe less elite educational pedigrees can ultimately deliver output at the same level. It also emboldened me, Bob, to try at scale what we did a few years later at UnitedLex. I can honestly say that without this little experiment at Jones Day, I don't think that UnitedLex would have come my way. It is only because in that small team of 20 or 22 people that we trained, that gave us the foundation for imagining and dreaming of something that could be done at the scale of thousands of lawyers at UnitedLex.
So this idea that you could outsource work to those who didn't traditionally perform it in the past is really what you're talking about, right?
Indeed, Bob. And I think that there are two parts. In fact, there are three parts to it, right? One is this whole notion that the legal transaction is a unitary, monolithic whole and must be performed from start to finish by the same person to provide continuity of representation and continuity of thought. That's a myth. I think this notion that it can be taken apart, can be disaggregated, portions of that can be automated, portions of that are high complexity can be run by extremely high complexity professionals situated in a place like London or New York, and the rest of it, which is relatively low complexity, can be offshored to places like South Africa, Australia, or even India. That, I think, was one of the enabling thoughts behind UnitedLex. And I think the time period there also was very, very interesting because India had just seen a big wave of growth in entry-level BPO. The country was poised to go up the value chain into KPO, knowledge process outsourcing, and specifically getting into areas like insurance, law, research, financial research, equity research, and areas that were considered a little bit higher up the value chain. And I think the success of Office Tiger in 2003, that was an event that really shook up the Indian market. I think everybody who was a working professional back in 2003 remembers how these two American entrepreneurs, Siegelman and Altshuler, kids back then, they were just, I think in their 20s and 30s, built a business of $75 million in revenue and sold it to R.R. Donnelley for $250 million. It made everyone sit up and say, why can't I do something like this?
Right. And that was one of the first real business process outsourcing success stories, I guess.
Absolutely. Absolutely. And in fact, not just any kind of BPO, Bob, but value-added or high-end BPO or KPO, if you will, knowledge process outsourcing.
Yeah. And during this era, I mean, we're talking late 90s, early 2000s, as you say, there were others starting into this area of legal process outsourcing, right? I mean, how did you come to How did what you were seeing at Jones Day and what was going on in that environment at that point lead to the founding of UnitedLex?
Bob, you are absolutely right to point that out. We stand and stood then on many shoulders. So many interesting experiments created the grounds for Dan and I to start UnitedLex. On the one side, Alok Agarwal, who was
Dan Reed is your co-founder. Yeah.
Dan Reed, exactly.
Yeah.
On the one side, Alok Agarwal and Mark Mollenweider had founded eValueServe. Alok was one of the senior scientists at IBM and had come with this idea that he could have a knowledge center in India to all the research and filing and the patent research that IBM did. And IBM was filing 10,000 patents in those days. Of course, eValueServe grew very fast beyond simple intellectual property work into other areas like equity research and business research. But that was one. Then Sanjay Kamlani and David Perla, and Sanjay, I think, was part of the crew at Office Tiger working for Randy and Joe Siegelman at Office Tiger, had set up Pangea 3. On the other side, Microsoft had sponsored the creation of Intelivate, which was another intellectual property subsidiary. Ram and Sirisha had moved from New York and set up Quizlex in 2003 in Hyderabad. And Liam Brown had founded Integrion in 2000. So the stage was set. There were at least 5 or 6 very exciting young companies, all engaged in providing alternative legal services. And looking at this landscape, Dan and I we had 2 choices in 2005. We could start something from scratch, or we could acquire 1, maybe even 2 of these existing players and build on top of them. The reason we chose to start UnitedLex as a fresh company is one and one only. We shared a vision that if we are getting down this path, then we'd like to build something that looks and smells a little bit like the Accenture of the legal services domain. In other words, we go to our clients with a strong sense of the best practices that they should be following in this domain. We have the ability to bring technology with our services. And then, of course, we provide both nearshore and farshore services as needed. But the idea was that we would be a company that would be predominantly annuity driven, have long-term and deep relationships with clients, rather than a smattering of projects across hundreds of clients, which tended to be the paradigm back then.
So you saw yourself as different than the Pangea 3s of the world at that point. You thought you were bringing something different to the table.
Very much so, Bob. Very much so. We thought that functionally the areas and the service types that we're providing may resemble each other: intellectual property, litigation support, and contract management. There, I think, is where the similarity came to an end. Because if you looked at the manner in which we went about executing that vision, we were always asking our clients the hard questions around how their practice was set up. We weren't just happy taking the project work that they were throwing to us for cost reasons. We wanted to participate in the restructuring of the larger function itself and become a long-term member, and to really become an extension of their global workforce and create, therefore, an annuity revenue base. And in very early days, that's the shape that UnitedLex took. And even today, I think more than 80 to 90% of its revenues are annuity-based in nature.
Yeah. So you founded UnitedLex, and what was the reception? How was it received? How did it do?
I think UnitedLex was very well received by the market. I would say the timing, of course, was very good. There were 2 or 3 things that were happening in the broader landscape that made the timing so very excellent. The first aspect was the litigation cycle. That really was the heyday of the Section 2 tribe deep discovery litigation, with hundreds and thousands of documents flying across, and the typical discovery cycle lasting about 2 to 3 years, with massive costs associated with it. So optimizing that was a very high priority for Fortune 500. The second, I think, was related to the twin emergence of P2P CRM and CLM software categories in that period. If you remember, Ariba had been founded in 96, Mtoris in 99, and then, of course, a whole bunch of other companies in the early part of that decade. And their clients were looking to get the legacy portfolio buy-side contracts onto the system. They didn't have any kind of artificial intelligence at that time, so they were leaning towards LPOs and alternative legal service providers to read their legacy procurement contracts, extract the data, and upload them into the P2P systems. That was one driver. The same driver was coming from CRM systems, implementing the Salesforces and the Kanas and the Siebels at the time. And then, of course, thirdly, the standalone CRM companies. And at that time, the landscape was dominated by companies like Nextens and Selectica and Upside Soft. And these companies are all gone now. But that was the landscape back then. The clients were either looking to ingest data and needed low-cost resources, or to read business documents and legal documents in the context of litigation, or to read on the more higher end intellectual property documents to assess patentability or prior art in the context of intellectual property. Those were the three big drivers. And I think we were very fortunate that demand was not an issue. So it was merely a question of restructuring the supply to become a part and parcel of the client's DNA and to make that into an annuity. The second major challenge, and I think this was something both Dan and I believed very deeply in, was the role of technology. We really never wanted to be a company where we would get the work and then ship it back to our client on an email or on some sort of secure server or file protocol. We always wanted to have a platform-based delivery model and to keep exploring how technology can be used to simplify the work and even automate it, even if that meant cannibalizing our own headcount. At that time in India, the success of BPOs and KPOs was measured by headcount. And if you were the type of company that was simultaneously investing in technology to automate the headcount, you were viewed as somebody standing on a tree and cutting off the branches of the same tree. So it was counterintuitive, Bob.
Yeah. So in 2011, you made the decision to leave UnitedLex and sold out your share in it. Why did you do that? What was your thinking at that time about what you were doing and what you wanted to be doing?
Yeah. Great question, Bob. I think the seeds of that really go back maybe 2 years earlier to probably the headiest moment of my personal success at UnitedLex, and that was the transaction with CSC. Early in 2009, we had just parted ways with the contract manager at Sirion, and I had to go, at UnitedLex, and I had to go and meet with all of his prospects, one of which was CSC, which had just got a new general counsel in the form of Bill Deckelman and a new CEO in the form of Michael Laurie.
Yeah, Computer Sciences Corporation.
Computer Sciences Corporation, now renamed and rebranded as DXC, and which ultimately ended up acquiring HP as well. So it's a question of the mouse swallowing the elephant.
Yeah.
So back then, the erstwhile CSC, Computer Sciences Corporation, and their brand new general counsel, Bill Deckelman, we were sitting in a lunchroom in Falls Church, and the conversation was around putting together a very vanilla contract repository for their 430 enterprise contracts, which were driving the bulk of their 11 billion of non-federal revenue. And during the discussion, it transpired that Mike Laurie, the new CEO, had placed 3 priorities before his leadership team, one of which ironically was something called contract education. And when we asked Bill what it meant and what Mike meant by it, he said, look, Mike thinks that we have great salespeople at CSC and we have great delivery people. The salespeople win deals by showing empathy, by understanding the unique operating environment, the unique operating culture of a given client, and tailoring a specific bespoke solution to fit their exact needs. That's how we win the business, empathy. The delivery people, on the other hand, create huge value for CSC by standardizing, by industrializing these processes at the back end, because otherwise we would have nothing but skill fragmentation and a collection of bespoke solutions. So they exert this normative pressure to streamline and standardize these very, very bespoke solutions into a set of standard delivery processes. But this process of streamlining and standardization is diametrically opposed to the very specific commitments that have been made. And that results in a lot of gaps opening up between what was promised and what gets delivered. And hence, Mike calls that contract education. Is there any way that the front end of the organization, the sales organization, can educate the delivery side of the organization, the back end? Hey guys, these are the promises that we made. Make sure that you deliver to them, make sure that you adhere to them. That was that problem. And we asked Bill, I said, hey, Bill, why are you then paying us hundreds of thousands of dollars to have an army, a team of lawyers ready, just capturing the legal information, negotiating these contracts, and mapping the deviation from your preferred legal terms that is sitting inside these 430 enterprise contracts? Why don't you ask us instead, whether we do it with human beings or we do it with technology, to connect the bridge, to be the bridge between the sales and the delivery organization? Why don't we capture the obligations, milestones, and the deliverables instead, and really enable legal to become that bridge? And Bill absolutely loved that idea. I would say the manner in which he embraced it and understood how it was a timely idea for a CSC makes Bill probably the most frontline legal visionary in the big supplier segment of that period. And I think I've tracked his career since. He's gone on to do many bigger and bolder things since then, some of them with UnitedLex, but that was definitely an early indication of Bill's vision. And that gave birth to LexBase, the system that we built for them, which drove obligation management, and tens of thousands of CSC service delivery people started working on it, and I think still work on it today. I think the success of that deal, which was several $1 million and more than 50% of UnitedLex's revenue at that time, emboldened us to think that we could repeat this deal with several other major suppliers in the months and the years ahead. And 2010, I think, Bob, coming back to your question of why I left the company, was a year of massive disappointment. The CSC deal on the one side was going swimmingly, but our POCs with BT, with Capgemini, with IBM and HP were not going that well. And net, it really showed me on the one side the difficulties of creating a software product inside a services organization, not a very easy thing to do. And secondly, understanding how building something for one company without taking the time to understand its larger situation within the landscape is not a good way to start the journey for a software product. Net, by early 2011, notwithstanding the general success of UnitedLex, I was already feeling a little disillusioned by this particular pinprick. And I think I wanted some time off to reflect and understand that. And I think the opportunity to come in and be an entrepreneur in residence at Stanford, to join the Center for Legal Informatics is a temptation I couldn't resist. So that's what led me to part ways with UnitedLex. And I think I'm very fortunate because for that 2 years that I spent at Stanford, it gave me the chance to reflect at this journey at UnitedLex, and particularly the journey around LexBase, that pinprick, and understand the two very fundamental mistakes that I had made. I think had I not left UnitedLex at that time and gone to Stanford, I would never have understood the two big mistakes that I had made.
Yeah, well, so you left and you went to Stanford, but that, well, you can tell me about the two big mistakes you made, but it sounds like that experience with in creating LexBase and thinking about that is really kind of planted the seeds for you for what you are doing now. But what did you realize were the two fundamental mistakes you made?
You're absolutely right. You're absolutely right, Bob. The continuity, this notion that contracts fundamentally are about the promises, and technology and solutions should be about keeping those promises rather than architecting them. That seed had already been planted and is at the heart of Sirion today.
Yeah.
But coming back to those two mistakes, I think, and I think they're relevant for any person aspiring to build a software product in any part of the world today. The first is look at the fat end of the wedge, not the thin end of the wedge. So if there are 150, 180 jumbo suppliers in the world today, companies like IBM, Accenture, who are delivering services at scale, that's the thin end of the wedge because there are only 150, 180 of them.
Right.
And building a product for them is inherently risky because it's such a small group of players and they're so big. On the other side, if you look at the fat end of the wedge, they have tens of thousands of clients who all share a common problem. We took months and months to negotiate a very complex deal with an IBM or an Accenture. How do we know if they are keeping their promises? How do we know if they are complying with all their obligations and milestones and deliverables? And is there any kind of technology that can help us to close the gap between the promise and the reality? So that was the first mistake, designing a technology for the supplier rather than their customers. We should have used the CSC experience, frankly, to reverse architect the product for companies who are the clients of CSC and so on. That was the first mistake. Knowing who your audience is, going after the more distributed part of the problem, going where the perception of the problem was more acute.
And because that's potentially a bigger market, or because that's where the pain is felt the most?
Both. Definitely the first, because it's a much bigger market. You always want a bigger market,
right?
But also because the pain is more acute. The reality in these complex deals, Bob, tends to be that the company IBM or Accenture, who you're monitoring, ends up rebadging and absorbing the very people who used to perform that function for you as full-time employees earlier. So the same people who you would have gone to and said, okay, tell me how we are performing in IT infrastructure or in application development are now employees of the service provider. Right. So you've lost access to your performance data. It's become part of the supplier data. And that's the bit we didn't pick up on, is the information asymmetry.
Yep.
Yeah, the second problem, I think they used to call it the 5-minute rule in software design back then. What do your customers do 5 minutes before they log in, and what do they do 5 minutes after they log off, as a way to stress test the intended width of your functionality. I personally like to think of it as the 500-minute rule. What are they doing for 5 hours before they log in and 5 hours after they log off? I think applying that rule to the obligation management capabilities of LexBase, we quickly understood the problem, both for the supplier and for the buyer, was not just tracking obligations, milestones, and deliverables. It was a whole lot deeper than that. It began with this huge mass of a contract, hundreds of pages, sometimes thousands, and understanding what was in there. And those days, there was no AI. So there was manually, and even UnitedLex used to do this manually for CSC. We had a team of 30 lawyers literally reading and combing these contracts to extract the deliverables. So can you build technology to interrogate the business outcomes that are embedded inside these contracts? This is a good point, actually, to pause for a minute, because in 2020, the AI aspect of contract technology has exploded. Right. And I think on your show, Bob, you've had several founders, people from companies that are leaders today in contract AI, people like Mark Harris at Noble and others. Yeah. And I think it's worth pointing out that virtually 98, 99% of the technology, the patents that are out there in contracting AI today cover 70 to 80% of the surface area of a contract, but only touch on 10% of its business value. And that is the legalese or the legal verbiage inside the contract. The names of the parties, the insurance, the limitation of liability, the payment terms. These are standard legal terms or negotiated legal terms that appear on the surface of the contract. And yes, they occupy 70-80% of the surface area, but they are in fact, because they are legalese, all they do is they manage tail risk. They distribute the liability for the occurrence of extremely unlikely events amongst the two contracting parties. Whereas the majority of the business value, 90% of the business value, what is the description of services, what are the service levels, the business, the milestones, that is sitting at the back end of the contract, buried in exhibits, schedules, and annexures, and gathering dust. And this technology that's sprung up over the last 10 years does very little to address that. So we thought to ourselves, if we are doing something like this, let's not focus on the surface of the contract, on the legal metadata of the contract. Let's get inside and let's go right to those schedules and annexures and dig out those obligations, milestones. And yes, we recognize that those are going to be more complex problems from an engineering perspective. Just to give you an example, the governing law of a contract, at the end, all you want is the word Austria to come out, right? That's the governing law. But if it's an obligation, it's going to have a multiple set of properties. An obligation, I like to call it a data diamond. So an obligation just to provide, let's say, an insurance certificate at the end of the year, you're going to want to know what is the value of that insurance certificate, what are the heads of insurance it covers, what is the criticality, who is the obligation owner, what is the region. And all of these are little facets of a data diamond that you're progressively uncovering from the body of the contract. It requires an order of magnitude higher level of technology than simply extracting the word Austria from the surface. So that, for me, is the AI bit that has really preoccupied the company over the last 6-7 years. And I think will increasingly become the focus for contracting AI for the rest of the companies that are out there in the space in the years ahead, Bob.
Yeah. And are you, I mean, you reference the fact that there are other companies on the market. Are you suggesting that other products on the market are not addressing this business value in these agreements?
Very much so, Bob. And I think there are multiple reasons for that. The emergence of contracting AI has been very closely linked with the re-emergence of CLM generally as a software category over the same period, let's say 2009 to the present period. And over the same 11 years or so, as CLM has made a big re-emergence, led by companies like Aptus, Conga, Icertis, and others, I think the companies who are adopting them have faced this problem of having to quickly digest these hundreds of thousands of legacy contracts and onboard them into their newly adopted CLMs, and hence the emergence of Seal, of Kira, and of many other AI companies to quickly read through these contracts. Of course, the other use case has been the more transactional use case of M&A and of due diligence and extracting data from business documents to enable those business transactions. But I think very few companies have said, can we use the same technology to ensure that what was promised to us in the contracts actually gets delivered? And that's the problem that Sirion has been focusing on for the last 8 years.
Yeah, I mean, the problem that I've seen, and it sounds like this is exactly what you're going after, is that so often the case is that these big contracts get signed, and that signing is effectively the end of the process. I mean, you know, they get delivered on, but the actual the promises that are made in that contract or the obligations that are created through that contract are not well tracked or even fully understood or remembered after the signing point. Is that fair to say?
Absolutely, Bob. 80% of US civil litigation today is related to contracts. And, you know, my data versus your data, my perception of what's inside the contract versus yours. 1/3 of corporate profits today are spent on tackling this civil litigation. IACCM, which is the Global Contract Management Association, estimates that inefficient contracting causes organizations to lose more than 9.2% of their annual revenue. And I think, coming back to your point, because of this inefficiency between tracking what was promised in the contract versus what was actually delivered, buyers end up losing anywhere from 5 to 15% of the contract value. Given that today $30 trillion is purchased annually as services, as a total of 50 trillion of third-party global spend. And of that, about 15 trillion tends to be complex services spend. If you apply that 10% filter to it, it's anywhere between $1.5 to $2 trillion of direct value leakage that's taking place as a result of not being able to monitor what the promises were in the contract and measure them against what was actually delivered. I mean, this notion of bearing a contract in a cemetery, right? Like a dead body in a cemetery, as opposed to treating it like a newborn and understanding that this is the beginning of the journey. Frankly, it really has not stood the test of time, this idea.
So in both sides to the contract suffer as a result of that. I mean, this is not just one side. I mean, you mentioned before the kind of the thin edge versus the thick edge of the wedge. But both sides of the wedge in these contracts are losing money as a result of this.
Absolutely. Let's go back to 2009. That conversation and that meetings with the Bill Deckelman and his COO Russ, etc. Why was Mike so fixated on contract education? Mike, as the CEO of CSC, had far bigger problems. For those who care to comb the pages of history, CSC had just come down from $17 billion in annual revenue to less than $15 billion, and it was to go down even further in the years after 2008, and 9 to maybe almost 13 or 14 billion. So Mike had his hands full. He had much bigger problems to deal with at that time in CSC. So why was he focused on contract education? I mean, just look at the things that were happening there. CSC's contracting process, they were bidding the prices they were bidding because they were presuming that they would get a higher amount of wallet share and business from those clients in Y2, Y3, Y4 of those long-term contracts. Those wallet shares were not getting realized because there was tension during the transition and the implementation phase itself. So the business case that they predicated their pricing on was not getting realized. Then, as a result of missed obligations, missed service levels, they were getting hit with service penalties throughout that were eating into their profits. Then, because their account delivery managers didn't have an accurate idea of what was sitting inside the contract and what had been committed to the contract, the clients were pushing them around and asking them for A, B, C additional services without remunerating them. So that had invoice leakage of a fairly high kind. And then there was no golden source of consumption against the promised base charges and the volumes. So there was no way of accurately charging out the values and volumes that were being delivered to their customers. That was another source of pretty big leakage. And at the most toxic end, issues and actions that should have been speedily resolved were instead festering and becoming claims and disputes. So much so that Delphi, which was one of their, the automotive company Delphi, which is one of CSC's largest clients at the time, was suing them for more than $200 million. So very much, yes, it's a problem both for supply and of course, the most everyday routine outcome of a lack of trust in these situations is the lengthening of DSOs. And I think CSC's DSOs at that time were extremely inflated as a result of this. The payment cycles, they were well north of 90 days. So those were some of the manifestations from a supplier's perspective. From a buyer's perspective, there's another whole panoply of problems, right? You don't get what you contracted for, it hurts your business. Ultimately, you are working with an IBM or an Accenture. Yes, cost is a big factor, efficiency is a big factor, but ultimately you are hoping that they will be your partner in helping you grow your business fundamentally. Let me put it this way. They used to call it the Web 2.0 paradox. You know today that your IT department, your logistics department, internal departments are only going to be able to do A, B, and C. So you don't even dream. Your very dreams are constrained by the notion of asking them for D, E, and F. So once you outsource to an IBM or an Accenture, it's like the blinkers being taken off a horse, right? You can ask for D, E, and F. Hell, you can go for the entire alphabet if you need. That's the notion. And that expansion of demand that drives the value with the supplier is also meant to drive value for your business, which never happens because nobody's sitting there monitoring that relationship. And then, of course, there's value leakage of various types and so on and so forth, Bob.
This sounds like really what you're saying is that the industry has just been thinking about contracts all wrong, and that they need to be thinking about them in a different way. Is that fair to say?
Yeah, I wouldn't say that it's a black and white, right or wrong per se, Bob. I think it feels a little bit like that because we're looking at it with the benefit of 2020, but life happens slowly. And the way I would put it is, if you go back 100 years to the end of the First World War, let's say to the time that Ford was building his Model Ts and experiencing surging demand in the early 20s, he could dream of a world where he would go and buy 100,000 acres of virgin forest in the Amazon to grow the rubber to build the tires for his Model Ts. I mean, that level of vertical integration, in a sense, is unthinkable today. Through the end of the Second World War and thereafter, the global supply chain was born, and this notion of relying outside your company on your core suppliers became part of the management lexicon. I think that is a given. And by the time you get to the mid-1990s, let's say 70, 75 years after the First World War, the notion of core competency is very deeply ingrained in management philosophy. And at that point, I would say that the physical goods that you make versus the ones that you buy and rely on your suppliers for, that notion is very well established. I think the last 25 years really has been a journey on the inside of the house and understanding what are some of the services that we deliver for ourselves that could be better delivered from outside the house. So that's one, right? The IT, the logistics, the facilities management, the R&D, can we get them more efficiently as outcomes from third-party suppliers? And then equally interestingly, and I think this is a more submerged wave, people have started looking at some of those commodities that we were buying from suppliers, that first 75-year journey, and asking, can these be packaged together as business outcomes? And can we consume them more as services than as goods and capital goods instead? So one small example in this will make sense. In the telecom universe, people used to buy companies like Verizon, AT&T, they would buy telecom equipment for their network operations center from companies like Ericsson, Huawei, etc. This was the case. This was the dominant buying model for telcos till maybe 10, 12 years ago. And right around 2006, 7, 8, particularly after 8, most telcos switched from buying capital purchases of telecom equipment to buying managed network services. And I think a lot of the disquiet that you see worldwide around Huawei today stems from that. The fact that they don't sell telecom equipment per se, but managed network services. It means that their people, Huawei's people, are coming in, installing the equipment, managing it, repairing it, operating it, and what they're responsible to their clients, who happen to be the telcos, are the painted outcomes: uptime, availability, jitter, latency. So this level of presence and continuity ensures that the people from the telecom equipment have continuous access to the network. It's not just a one-time sale of the equipment and now I'm gone. So this is the new world. It's the new world of business outcomes. And I think that contracting, coming back, contracting, to your point, Bob, contracting was designed for a world of P times Q, of buying widgets and commodities. And for that world, the contract, it's very appropriate to put it in the repository or bury it in the graveyard and forget about it, because all you want from it, frankly, is the price.
Right.
And that's how the old world is structured. The contract would be sitting in the graveyard repository. The ERP system would come in, take the price from that, put that into a price register, and the price register would be the building block of the next journey, which would either be in the ERP or in the P2P system. In the new world of buying business outcomes, you cannot get rid of the contract because it has so many complex parameters. It has to be a governing light, a beacon to guide future conduct. And if you do that, the relationship will suffer, as we have seen.
We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. Now, let's get back to this week's interview. So how does Sirian bridge those sort of two sides of that relationship, going from the negotiation and signing of the contract to the relationship that happens after that?
There are many enabling technologies that come together to make something like this possible. But I would say the most fundamental of them is also probably the most revolutionary. The notion that contract management systems, by their very nature, are back-end systems designed for one company. And we feel this is absolutely wrong. Contract management systems must always be deployed as a network connecting various companies, buyers and suppliers, so that you can look at the system and say, oh, this is our contract sitting right here. You and me, I'm Unilever, you're IBM. We can both see the contract. And oh, by the way, here is a list of all the obligations that IBM is supposed to do, that Unilever is supposed to do as a client. I call that outcome baselining. And so this notion of a shared truth, of a single source of truth between the contracting parties, that for me, whether you call it a permission ledger, whether you call it fancy words like blockchain, or you just call it a distributed access, old-fashioned, either way, that's the first principle, the notion that people must work together on a contracting system. The second, as I said, is using advanced technology and AI, not just for the surface and the legal metadata, for the deeper business outcomes, the price books, the rate cards, the service levels, the obligations. The third, and I think the deepest analysts of this space, people, like within Forrester, Andrew Bartels, or Patrick Norton and Gartner, they will all point to this. CLM and contracting technology has been an island for so long, a technology island, simply because it is not bolted on to the backbone, the enterprise backbone, ERP, P2P, CRM, and building those bridges between the contract system and the enterprise business transaction systems. That's an absolute key. So how you build those bridges, whether they are straightforward APIs or they are built on more elastic technology that allow data to flow back and forth, that allow those promises to be secreted from the contracting organ into the bloodstream of the enterprise. That for me really is the electrifying vision of contracting in the future. And then of course comes the kind of visualization layer sitting on top. If you knew what was in the contract, if you knew what the actual performance was through these elastic bridges, why can't you predict the invoice? Why can't you describe how your contract could have been better written in the first place? And now we're getting into really cool stuff.
So then it starts to come back on itself, I guess, in the sense of providing learning and instructing going forward, learning for the past and instructing on going forward.
Absolutely.
Yeah. So where are you now, and where are you hoping to take this? I mean, I think you just gave us a hint of where you're hoping to take this, but where is the company now in terms of adoption and development, and what are you looking to build going forward?
Yeah, I think that from a pure adoption perspective, we have 200 clients worldwide. But because of that very unique aspect that I mentioned, how our software allows the buyers and the suppliers of each client to work with them collaboratively on Sirion, it already means that more than 250,000 enterprises are already working on Sirion. So this network effect of enabling people to come onto the platform, even though they may not be licensed users, this has created a much deeper impact into the Sirion ecosystem than simply being a back-end software like a traditional CLM, analog CLM, I like to call them, like an Icertis or an Aptus or a Conga, who are just sitting in the back end for one individual buyer at a time. So that's the adoption side of things. I think from a futuristic perspective, functionally speaking, I'll take that question first. I think functionally speaking, we were very focused, Bob, on the post-signature end of the life cycle, right? We were always more focused on what happens after a contract gets signed. And most of our clients, about 60% of our clients, tended to be buyers, big buyers, who were looking to monitor their suppliers' performance using Sirion or audit their invoices using Sirion. And about 40% tended to be big suppliers like CSC who were using our platform to deliver to their large customers, their strategic clients, and make sure that they were complying with the promises. I think in recent times, we've realized that this notion of staying very, very specialized on the post-signature was a fallacy on our part because very large suppliers, or for that matter, companies in general, are unlikely to have multiple contracting systems, one to create a contract and store it, and yet another one to kind of monitor what's inside it. So we dialed back into the functional arc and developed our own authoring and repository systems as well, which we launched. And I think were rated very highly by Gartner in the very first Magic Quadrant last year. So that really, and then of course, the AI that we were using purely as an efficiency tool to onboard new contracts for our buy side and sell side clients. Now we've released that in a competitive market because obviously the technology that can pull the far more complex obligations and service levels from a contract can very easily pull the legal metadata. It's like asking the world champion in motorcycling to ride a bicycle. Of course, we can do that.
I guess, I mean, you mentioned Gartner. I was just, just yesterday, somebody at your company sent me a copy of this Spend Matters report, white paper that talks about Syrian Labs. And I mean, it still, I guess, sort of centers on that post-signature part of it. There's a part of that report where it says that your differentiating strength that no other technology provider we have seen is comparable is as a post-signature contract management solution based on sophisticated natural language processing technology that supports intelligent ingestion and storage of contract terms, monitoring of contract execution, performance, and management of variances and contract changes. I mean, that kind of says it all right there, right?
Very much so. Very much so. The Spend Matters folks have a beautiful way of encapsulating that. They call it contract value management.
Right. Yeah.
And they use that term CVM to differentiate providers who are interested in the promises that are made, as opposed to just bean counters for their transaction.
Yep. So when you talk to potential customers about this sort of single source of truth concept, do they all get it, or do you have to sell them on it?
Yeah, great question. While the journey from buying widgets to buying business outcomes has been a secular macro trend over the last 25 years, the notion that one needs to amplify one's effort in monitoring those business outcomes has not been a secular trend. And if 100% of the companies moved in the direction of buying business outcomes, only maybe 15 or 20% of them truly understood that we would have to take a different approach now to supplier governance if we are going to get the value that was anticipated or the business case that was envisaged. And I think for the remaining 80 or 85%, it's very much an evangelical or consultative sale. Absolutely, Bob. I think that there is a growing body of awareness within the larger corporate enterprise, whether it's legal, supplier governance, even procurement. And I like to call them the enlightened procurement folks. If you look at the traditional procurement function, their incentive structures are very oriented towards realizing savings at the front end when you're negotiating. And as a result, they don't really care that much whether the savings that were anticipated to flow post-signature end up getting realized or not. That's left to the business. And the business very rarely, as you correctly observed, has the wherewithal to go and, on a granular atomic basis, monitor whether each of these deliverables, obligations, and service levels are being met. And legal, of course, is very far from the action at this point. So this kind of dispersal or this fragmentation that you see post-signature creates a lot of the dissonance and visibility or dysfunctionality that drives the non-realization of this value. And I think there is now, as we start to connect the dots, as the awareness builds that this is hitting our bottom line, that 9.2% of our annual revenue is not getting realized, 5 to 15% of the contract value is getting dispersed. That's when the CFOs will start sitting up, the CEOs will start sitting up and making this a higher priority. We are now finally, over the last 2 years, seeing this going past a functional priority, either at the IT or the general counsel or the service delivery level, to the CFO level and even to the CEO level.
Ajay, I've been asking you a whole bunch of questions for an hour now. Let me ask you what you'd like to say. What else would you like people to know about your company that we haven't talked about?
Thank you for asking that question, Bob. I think we've covered most of the points that I wanted to talk in terms of technology. How to create a smart or a self-executing contract that is digital from the get-go. We've also spoken of how to use artificial intelligence to read not just the legal elements of a contract, but the more complex, the more nuanced business end of the contract. We've spoken about how elastic technology can be used to monitor obligations and service levels and compute real-time performance instead of relying on the supplier to report on them a month or 3 months later. We've spoken of predictive invoicing. We've spoken of the power of data visualization. But let me just use this one concept to tie these threads together and, in a sense, bring it home for people. Contracting ultimately is a promise of value delivered. And not being able to connect the dot between the promises and the value that's promised inside a contract with the business transaction systems where all of that ultimately ends up happening makes no sense at all. Contracting should be hardwired, should be bolted on to the business transaction systems in large companies. It should be part and parcel of how we do business. And I think that if we can play a small role in bridging that gap, in closing that fissure that is there in corporate business tool landscape today, I think that would be where I want Sirion to be.
It makes enormous sense, and clearly you're getting traction and getting success and getting recognition for your efforts in that area. So congratulations on that. Well, Ajay, it's been a real pleasure to speak with you today, and a really fascinating conversation. And I want to thank you for taking the time to sit and share your story with us today.
Thank you, Bob. Thank you. You've been a very easy person to speak with, and your deep understanding of the space shines through the entire conversation. Really enjoyed our conversation. Thank you very much.
Thanks, and I hope you get unstranded and get back to New York sometime soon. Who knows when that might happen, but sooner rather than later, I hope.
Absolutely.
Yeah. Well, we've been speaking with Ajay Agrawal, who is originally the co-founder of UnitedLex and now the founder of Sirion Labs. This is Bob Ambrogi. Thanks, as always, to Ben Ambrogi and Populous Radio for producing and editing our program. That does it for this week. Thanks for listening.